Okay, I think we have just about everybody here. Good afternoon and welcome. I am Ed Clear, representative from New Albany, chairman of the Child Services Oversight Committee. I want to thank everybody for being here, including those who are joining us online. I believe, how many folks do we have online? 2? Okay. Why don't we start with introductions around the table, and then we'll let the members who are online introduce themselves. Let's start with Senator Ford, if you just want to say who you are and whom you're representing.
Sure. Thank you, Mr. Chairman. John Ford, State Senator, District 38.
Sean McRindle, Basher Children's Home.
Carolyn Jackson, State Representative, District 1, Hammond and Whiting.
Terry Stigdon, Indiana Department of Child Services.
Joan Smith, Indiana Department of Education.
Sure.
Kenworthy, Grant Superior Court 2.
Joan, is your microphone on? I didn't. Is it coming through? Pull it a little closer to you.
Hello.
We're going to take a look at that. That was Joan. Is the light on? Okay. I don't know.
Hello.
Are you hearing it over there? Okay. Maybe it's just where I'm at. That's fine. I'm sorry. Judge Kenworthy, try again there.
Sure. Dana Kenworthy, Judge of Grant Superior Court 2.
I'm Michael Moore, Indiana Public Defender Counsel.
And joining us virtually, I think we have Senator Mervan, correct? Senator Mervan, can you hear us? Would you like to introduce yourself?
Please unmute, Senator. You're on mute.
Talk. Hello, sorry, I'm Frank Mervan, Senator Mervan from Lake County.
Good to have you with us from afar, Senator. And then who else is online?
It's Ray Feller, State Director of DA El Casa.
Hi, Ray. Thank you for joining us. Okay. All right. First thing we have is the minutes from the November 1 meeting. Everyone should have received a copy by email, and we have paper copies of everything up here on the table to the right of Senator Ford. If anybody needs a paper copy, I think there are enough copies. If members of the public would like copies, feel free to grab one. Hopefully everybody's had a chance to review the minutes. I'll entertain a motion to approve the minutes.
So moved.
Is that Judge Kenworthy? And a second, Mr. Moore, thank you. All right, we have a motion and a second. All those in favor of approving the minutes, say aye.
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 Anyone opposed? Minutes are approved. Now we're going to move into a discussion, follow-up discussion of the bulk of the content from the last meeting. Everyone should have received a three-page, two pieces of paper, three-page document. Child and Family Welfare Agency's recommendation to the Child Services Oversight Committee. So I had asked Mr. Daly to compile what his members, the IARCA members, brought to us at the last meeting and try to take inventory of what was presented and categorize things into potential action items. So Mr. Daly, did you want to say a few words about what you put together? I appreciate the information you compiled here. And again, we have extra copies. If anybody in the audience would like a copy, feel free to grab one.
Good morning, committee. Thanks so much, Chairman. It's Chris Daly from the Indiana Association of Child Advocates, Resources and Child Advocacy. Just wanted to quickly walk through, again, thanks so much to the committee for taking so much time at your last meeting to hear from child and family welfare service providers from around the state. I don't want to go back through everything, obviously, that they presented. So just want to hit a couple highlights, and then if you all had any follow-up questions or additional thoughts. One of the main themes was streamlining the background check process. There's a couple ways to do that. Currently, under the governor's existing order and some similar federal orders, DCS can approve waivers to the existing background check process. And those waivers would be on the condition that the agencies don't allow those employees to have any contact with children or child records. That's a quick amendment to what's in here. It should be children and child records. There will need to be some request of the governor's office to extend the existing state emergency, even just partially, so that it addresses this issue on background checks. Right now, that's set to expire, I believe, at the end of this month. And then again, we had also talked about some way to just bigger picture facilitate the background check process. Background checks are obviously an important part of the hiring process for child and family welfare agencies. They're just incredibly burdensome right now. So looking at what Florida and Illinois have done in creating a clearinghouse, that would be a much more long-term solution, and it would require legislative action. There's probably a medium step there of incorporating the principles under the waivers into statute. Again, that's something that would need legislative action, but it's something that could be done while we figure out the bigger picture of a clearinghouse. And the clearinghouse wouldn't apply just to child and family welfare. There's any number of employees around the state who need these important background checks, but it's a clearinghouse that could potentially incorporate all of those different sectors. And then again, just this was another point that was brought up around the operating margin for our nonprofit residential and foster care agencies. I know that was covered quite a bit. So the executive branch has the authority to reinstate that operating margin. If the executive branch isn't able to do so, then the General Assembly may need to step in on that issue. Related to that is the COLA for community-based services. So this gets into the weeds of how we fund child and family welfare in Indiana. Our residential and foster care agencies get an annual rate that's based on their cost report, but our community-based services, that's what Dee Sandrowski came to you all and testified on, are one statewide rate for those services. What was shared in the session last year or earlier this year was that DCS had not raised those rates for many of those services, not all, but many of those services since 2015. So we would just look at an annual COLA to raise those rates. Again, that's something that can be done with executive authority. If the executive branch isn't able to act on that, we would need the General Assembly to step in. And then back to that cost report issue, just this is number 4 on the second page, improve the cost report process. There's a number of recommendations that were raised. Because of the way these recommendations fit within the existing administrative rules that shape the cost reports, we believe all of these are steps that the Department of Child Services can take. And really, they're just ways in which we make sure these are the kind of core theme here is how does a rate that pays for services in 2022 cover the cost of those services in 2022? And these are just different ways that we can make sure that we have some additional steps in the process to make sure that those rates actually cover those costs. And then finally, we know that this is a important issue. The federal government's moving a couple different ways on vaccine and or testing mandates, making sure that our child and family welfare agencies who are going to be governed by those mandates have access to free COVID-19 tests. I think you all know this, but our agencies have been trying since January, urging and encouraging their employees to get vaccinated. A number of employees have. We do have, though, a number like any other sector of unvaccinated employees. So those agencies who are governed by Medicaid and Medicare statutes are right now under an order that will require them to will require vaccination with some exceptions. There will not be a testing mandate as part of that requirement. But then the requirement from OSHA for employers with more than 100 employees was released in early November. It's obviously being challenged in court right now and is on hold. But in the event that that goes forward, we'll just need to make sure that agencies have easy access to tests so that they can test employees, so we can continue to make sure our workforce is full and that we're meeting the federal requirements to keep our workforce safe and the families and children that we work with safe. So that's just kind of a quick run through. Again, you all spent a ton of time with agencies at your last meeting. We really appreciated the time you gave them. Just wanted to summarize this and give you a sense of some ways forward on each one of them. I didn't know if folks had questions or additional thoughts.
One question, go back to what you said is going to expire at the end of the month, please.
The governor's current public health executive order, as I understand it, others may have more updated information, is right now set to expire at the end of the month. It could be extended again. It has been extended several times. It's under the COVID-19 public health order that DCS has been able to do some case-by-case waivers for background checks.
Has there been any discussion of that in the context of the bill draft that has just been released? For those in the room and those online who may not be aware, the leadership of the House and Senate announced last week that we would be convening for a one-day legislative session a week from today on the 29th. And there are several provisions in the proposed legislation that deal with continuing things after the state of emergency goes away, specifically related to Medicaid and SNAP. Has there been any discussion of this issue in that context?
There hasn't been, but there should be. It's a great point.
Director Stigdon, have you had any discussion around that? Should we? And what are the implications of?
Sure. So right now, what the public health order allows DCS to do is provide some waivers to current state statute. So current state statute only allows you to hire someone after their whole entire criminal background check has been done. When I say that, and again, we talked about this about a month ago, but that's a group of about 5 or 6 different types of background checks, some in state, some out of state. What the governor's executive order does is allows DCS to waive those. What DCS has chosen to do is on a case-by-case waive them. Case-by-case basis. We would just urge that it be done as a blanket waiver, again, so long as the new employees don't have any contact with children or children's records.
Director
So there
Stigdon.
are federal implications to that. Will, do you want to go ahead and?
Yeah, kind of Will Young, Legislative Director for the Department of Child Services, sort of wrapped up in discussion of any kind of state emergency order or federal emergency order. The Administration for Children and Families at the Health at HHS federally. There are some requirements, which is partially why we have those background check requirements in statute. According to their child welfare manual, claiming for children in those facilities regarding background check completion is kind of tied up in that. So case by case versus sort of broad waiver of certain background checks. That's the part we're sort of looking into right now, whether or not that's prudent and we'd be able to draw down those federal dollars if those waivers are in place. So that's just some background on some research we're doing federally. So.
You lost me. So are you saying that we're at risk of losing some the ability to draw down some federal dollars?
Correct. Yeah. So kind of wrapped up in this is our federal waivers under the context of emergency order. So on the state side, that's Governor Holcomb's executive orders. Federally, we have requirements that we're required to meet to pull down Title 40 dollars. They're numerous, but one of them are the background check requirements. And so that's why they're partially why they're in state statute, also just to protect child safety. Under the Child Welfare Manual at HHS, the requirement is that those be completed before we can draw down federal dollars regarding that child in that institution. And so in a non-emergency environment, whether or not we would be running afoul of that requirement to have them completed before the employee starts would put federal dollars in jeopardy. And that's part of what we're researching to determine what we're allowed to do in a non-emergency context.
Could there be provision made in that legislation, the proposed legislation, to account for that?
So that's what we're researching. But again, this is more of a federal issue, a federal requirement for a state. So if we change state statute, it may have no bearing on the requirement of the federal government. So that's what we're looking at.
Well, I think several of the other provisions in the proposed legislation relate directly to the intersection of state and federal action, specifically the ability to draw down the additional Medicaid and SNAP dollars, right?
Correct, but that also may be provided for under federal law as well. That's what the federal emergency order provides.
Okay, Senator Ford, did you have a question?
Could we do something where while the federal government is still in this state of emergency, that we're in providing the waiver, that we could still do it here at the state level and put it in the bill written like that?
That's the kind of
Until you
stuff we're
work
working
out.
into. Yeah, I'm not prepared to answer that today, but that's what we're trying to figure out from our federal.
So you are working on it?
We're trying to
Someone-
research that.
Okay, we're just on a very tight timeline, obviously, with the legislature convening a week from today. In fact, it's 20 after 12, so we convene in less than a week. I think the House convenes at 11 on. Yeah, rules is tomorrow, but the House convenes at 11 next Monday. So we're on a very tight timeline. So maybe Senator Ford, Representative Jackson, we need to look into this with our respective policy folks and make sure we're in conversation, part of the conversation about whatever may need to be in that legislation, because to your point, if the two rules committees are meeting tomorrow, we don't want to miss that window. So let's talk about that. Any other questions? Thank you, Mr. Young. Any other questions for Mr. Daly before we move on?
And then the only thing I would add to Will's great comment, he's exactly right that there are federal regulations. However, HHS, before the state acted, provided states the ability to broadly waive the background check requirement. As far as I know, that waiver is still in place. So Will is exactly right that if that waiver is pulled, it would then implicate some of the background checks. But just so we're all completely clear, if the governor continues the executive order, the federal government would have no problem with the state continuing to waive background checks because they have provided the state that same ability as well.
Okay. Did I see your hand, Judge Kenworthy? Okay. Anything? Oh, Representative Jackson.
Thank you. I just want to be clear that if this waiver is not pulled, that it will affect not only DCS, but also the service providers, correct?
Absolutely. Yes, ma'am.
Thank you.
All right. Any other questions? Okay. Thank you for putting together this document, Mr. Daly. It's very helpful. Last time we ran out of time because of the great discussion that led to this summary. We ran out of time for the alternative permanency options discussion, and Mr. Moore was gracious enough to let us save that for today. So are you ready to discuss that?
Thank you.
Thank you.
So I wanted to, the title's kind of misleading because these alternatives already exist. They're just rarely used. So what I want to talk about today is in the typical CHIN's case, you have contact, you have a filing, there's a fact finding. If found to be true, the services are ordered. At some point, there's a decision regarding permanency. And historically, we, like every other state, look towards reunification or adoption as the two primary options when there are other options like guardianships, paternity, and those kind of things. And so they're not utilized in Indiana as well as they could be. And the reason why is there are some barriers to that existing statute and a policy. I did an informal survey with some public defenders around the state. And it's not scientific. I just literally send an email or a listserv and say, if you had the option to resolve a case through some alternative besides reunification and adoption for those tough cases where mom and dad are just not going to get there where they need to be in 6 months. How many cases do you think that looks like? What percentage of cases could you resolve? And the picture is, there's fact finding and there's coming back for status conferences every 90 or six months, depending on what court does what. But public defenders, DCS lawyers are coming into court and they're just checking in. Nothing's been resolved. There's no alternative. The plan is reunification still, and it just goes on and on. So we're seeing an uptick of the number of cases that are not in permanency. Whoops, sorry. I skipped the slide. Up there, I'm sorry.
There's an arrow. I don't know if you can see it at the bottom.
No, I can't see it. Oh, there we go. Yeah.
Bottom left-hand corner. I think if you click on that.
Okay.
Go back. There you go.
So I pulled this from the report, I think produced by DCS, the FY 2020 Court Performance Measure Report. And this is showing a trend line of the number of cases filed and then the average time to permanency. So permanency means some permanency option like adoption, alternative placement, reunification, all the options there. And what we're seeing is a slight or a continual increase on the number of days or the median number of days it takes to find permanency for a child, even though the number of filings are going down. So that's the concern that we have, and we want to know why. We at the council are focusing on training more on permanency options for public defenders to help advocate for when they're in court.
Michael, do you want me to advance it up here for you?
No, I think I see it
sure?
now. I couldn't see the
Okay.
arrows before. This is another trend line looking at average versus median days. So average would be average amount. Median is where you take the highest number and lowest number to find the middle, the dead center. The average number of days it takes to permanency has increased since 2015, as you can see here, from 524 to 705.8. We don't have any answers to the reasons why, but we have at least a thought about what might help reduce those numbers. These are how it breaks down to the different types of permanency options, whether it be reunification, guardianship, adoption, relative placement, or APPLA, which is another planned permanency living arrangement. Typically those are older kids living in maybe an apartment or with some other setting. And you can see those numbers as compared to the national average are pretty high. Adoption is almost twice, not quite twice, that's 1,084 versus the national average of 730 days to reach adoption or guardianship and those kind of things. So this is what the number looks like. This is the pie chart that in 2020, this is what most permanency options look like. You can see reunification is the highest number. That's great. Adoption being second, but the other ones, guardianship, relative placement, those kind of things are small. And those are the kind of cases we're talking about right now. So we have a couple of recommendations. And some of these, we have some support and some we don't, because there are issues that have to be worked out. But one is the legislature gave the juvenile courts concurrent jurisdiction a couple of years ago to bring in an existing case. So there's a divorce or guardianship or paternity action. Juvenile courts in a CHINS matter can bring that case in, make modifications to the existing custody order, leave them in that case, and then close out the CHINS case, and the parties just move on privately, resolving whatever they have to do in the future. But what doesn't exist is the ability to commence or start a case in the juvenile court. That comes to head really with paternity more often than anything else. So you have a case from mom and dad signed paternity affidavit, or we know who dad is, but the parties just can't do the work they need to do to go establish paternity, which depending which county you're in, that might be driving down to another building, talking to the Title 40 prosecutor, doing all the paperwork to get a paternity started. So what we like to see is the juvenile court have the ability to commence the action within the juvenile court. The problem that has come up in some counties is that the way the statute reads in Indiana, the paternity statute, many 40 entities read it to mean that if paternity has been established already administratively through an affidavit, so when a baby is born, the father has the ability up to 2 years to sign an affidavit of paternity. Once that's done, by federal law and state law, paternity is established. That man is the father. And federal law restricts states from having this ratification process where a court comes in and really establishes paternity. You can't do that. Once the affidavit is filed, paternity's been established. Where our statute says if paternity has not been established, in terms of who can file attorney action, the statute allows DCS or the Title IV D entity to file a paternity action, but only if paternity has not yet been established. Well, some counties interpret that to mean, well, if an affidavit has been filed or entered into by a father, the paternity has been established, and they can't then commence an action to get a custody order to place a custody order into, so they can close the Chin's case out and move the case forward. There's been some creative discussions about a bridge order, which I really like. But in the meantime, we'd like to see the paternity affidavit or paternity statute changed to make it clear that even if a paternity affidavit has been filed, the juvenile court can commence an action solely for custody and support, not to establish the existence of a paternity matter. And so in this next slide, I'll show you that statute. We also want to encourage DCS, courts, public defenders, attorneys to look at guardianship as an actual option. Historically, guardianships were never agreed to by DCS unless the child was older, and they were often not seen as a permanency option because guardianships are by very nature temporary. They can be undone at some point in the future, and so they're not often explored. And a couple of barriers to that. One is just a philosophical and historical context, but if you're a grandmother who wants to get paternity or guardianship, you have to go hire a lawyer. You have to pay a filing fee potentially. You're looking at $1,500 to $2,000 to hire a lawyer to do a guardianship, and that's a barrier for most people. But if the juvenile court had the ability to commence a guardianship at the same time a Chin's action is being heard, they could avoid some of those costs. So we're looking for some support and legislation in the future to allow for that. And then bridge orders, as discussed before, I think it's a great idea. What happens now if the juvenile court has an order giving custody to either a parent or a non-parent? That's a private matter, and they can't file that in a filing that's public, like an adoption or family law matter, what have you. So there's the possibility of creating a bridge order that would allow for an order saying custody to this person, and not explaining why, because of a Chin's case or a termination case. So we were looking for support there. Here's the paternity statute I mentioned a minute ago. Here's the problem. If you look at the part that's not bolded, that's how it currently reads. So this is a list of people who can file a paternity matter: the mother, the putative father, the expected mother, the child, my next friend. And then it says the department, if no paternity has been established, that's the purpose in bold. So paternity of child has not been established, then the department can file the action. Or in 7, if the paternity of child has not been established, a Title 40 prosecutor through a contract with DCS. We're recommending that language that's bolded be stricken to clarify, or future or additional language be added to clarify that if paternity was established by way of affidavit, that those two entities could commence an action for the purpose of custody and support. We think that can resolve anywhere between 20-25% of cases in Indiana that are just lingering, just going back from status to status to status, because the parents just can't get it together enough to get a paternity order done. There's been some strides made. DCS created an app that works on your phone where you can actually fill in the information and then it makes a referral to the local Title 40 prosecutor, which I think it will help a lot. But again, you got to get the people to do it, and the best people to do it are the people that are in the courtroom. The other problem we have is people need lawyers, and public defenders just don't do this work. But if matters were held simultaneously with the Chin status hearing, most people have a public defender who can advise them of consequences to agreeing to, placement with father or placement with grandma or what have you. They can't be ordered to represent those people in that matter, but they can give the consequences and explain to their client at the moment. If you agree to your mom to give father custody and agree to paternity and give him custody, here's all the consequences that go with that. And so the person would have some level of representation at the same time. So these are just solutions we come up with. They're going to require a lot of legislative changes, and we're looking for some support in the future.
Has any of this been introduced in legislation?
No.
Okay.
We've talked to legislature, obviously. We've worked in work groups.
Pardon?
We've worked in work groups. There's 2 committees, the Child Welfare Improvement Committee and the JJIC, the Juvenile Justice Improvement Committee. A subgroup was formed, and some work was done, but it was decided that the members of that group, until this legislation was ready, because they're concerned about the child support part of it, that if there's some sort of ratification in law that allows the court to ratify paternity, that would interfere with our federal funds. So I get that concern. I don't agree with that. I think that does that, especially if we clarify and say if paternity was established administratively, then an action to establish custody or support only could be commenced by either of those parties.
Judge Kenworthy, do you have any thoughts on this?
I think judges would be very pleased if we had this fixed, because so often the same judge is going to hear that case. We just can't get it opened to hear it. And so that does lag. We see the same family coming back every 90 days or 6 months, and we say, what progress have you made? And the answer is none. And so this child has now sat another 6 months or 90 days and for no reason, for no good reason. So if we were given the authority to open that file, if someone asked for permanency by way of establishment of paternity or permanency by way of establishment of a guardianship, give the court the authority to just open that file so that order exists now in its own avenue, as opposed to the Chin's case, which will close. So another fix was discussed by amending the concurrent jurisdiction statute by adding some language to that. It's been probably 3 or 4 months since I was involved in that subgroup, that committee, but I'd be glad to reach out and get that language as well if you'd like to take a look at that.
Please. Other questions for Mr. Moore or comments from the committee? Director Stigdon or Mr. Young, does DCS have any thoughts on this?
Just briefly, Will Young, Legislative Director for the Department of Child Services again. Wanted to thank Michael for bringing this before the committee. DCS, as you mentioned, was a part of a subgroup with, I don't want to miss any participants, but at least was the judiciary, DCS, and public defenders. And so I know as of maybe a month, 6 weeks ago, they thought they sort of found some solutions in other states. And so it wound up not being the case. And so there wasn't a consensus yet on moving forward this legislative session on sort of the broader changes, but I think I can say that everyone on the group wants to find a solution, and it's just a matter of lining that up with sort of best practice for all the parties involved, as well as federal reimbursement, which is also a concern. So, but I guess the headline for DCS is supportive of the concept, but maybe just not quite ready yet for legislative change.
What's it going to take to get it ready for the legislature?
The work of this subgroup, I think, is just trying to figure out sort of what the best practice is for having cause numbers continue. And then it's very procedure based. And so making sure that all flows as well as lines up with our federal reimbursement policy. So
is the group still meeting on that?
No, the group decided that they wanted to plan for so 2023. So we're not currently working on legislation right now for 2022. I think it's ready personally, and IPDC thinks it's ready. We're a burden part of the process. Public defenders, we're seeing reduction in our numbers, and we're seeing public defenders just going to court 90 days, 6 months again and again with the same clients, and nothing's been accomplished. And this is one of the hurdles. There's many hurdles. This is one of the ones that I think is the easiest one to fix.
Well, there are several pieces wrapped up in this, right? So maybe there's an opportunity to take an incremental legislative approach, do something in the 2022 session, and then do something else in 2023.
It's a great idea. I think the paternity is, to me, the easiest thing to fix. Because some counties are doing this, and so if there's a federal reimbursement issue, then those counties have already been violating federal law. Because some counties will do this. When I say counties, I mean the Title 4D entity in that county will establish paternity, and there's an affidavit on file. When I say establish paternity, I mean file an action for support and custody. So I think this is the easiest one to tackle first.
Okay. Any other comments or thoughts?
Yeah, I think it's a good
Representative
idea.
Jackson.
Thank you, Chairman. Clear. I think it's a good idea, and I'm thinking that would save a lot of money, a lot of time, and I think it would also be very beneficial not only to the mental health of the child, but to the mental health of the family. So I would definitely be in support of something like that.
Senator Ford, any thoughts?
No, I mean, I would be supportive of this as well, but I think giving the committee some time to work it out is probably the best thing.
Yeah.
I want to follow up with something, Representative, if I may.
Please.
Thank you for saying that, because many public defenders will tell you that when a case just goes on and there's nothing changing, parents just give up. They suffer from fatigue, as do we, and as the courts and everybody. everybody's just tired of this family coming back and mom's still using, or treatment's not done. And the child's safe someplace, but we just can't get an order to put it in. And so I'm glad you said that. I meant to say that we all suffer from fatigue after a while. It doesn't impact either the mental health or at least the success rate of some parents. They just see failure on the horizon and just give up. And then we're talking about termination option. Experienced judges, but it's been, I hear a lot.
Well, I certainly want to respect the work of other groups that may be working on this or planning to continue working on this. But I think if there is an opportunity to take an incremental approach, you mentioned the paternity being the easiest fix. I'd be interested in looking at that. Representative Jackson, Senator Ford, would you all be willing to look at that with me?
Yes, I would, definitely.
Take a look at that with Mr. Moore and Judge Kenworthy and anybody else who'd like to weigh in. Maybe we could come up with an incremental approach. Oh, and Senator Mervan, yes, thank you, Director Stigna. He's not physically in front of me. I don't mean to leave out Senator Mervan, but I'm sure he would like to be part of the conversation as well, and certainly will be. Thank you, Director Stigdon. So yeah, I mean, if there's something we can do incrementally without offending the process, then I'm all for it. And maybe it makes the rest of the process a little easier next year.
I would recommend Sean Gorman from DCS too. He's the child support expert.
Say that again, I'm sorry.
Sean Gorman.
Oh, Sean Gorman.
Yeah, I think because the question is federally, is this going to interfere with the federal reimbursement? I don't think it does, but I know they want to get the answer to that. I would want that answer too.
Okay. Yeah, very important. All right. Any other thoughts on that? Okay. All right. Well, thank you. And thanks again for your willingness to hold that over from the last meeting. We will move to number 6 on the agenda, which is the rate setting overview and conversation. We have 2 pieces. We're going to start with a presentation from DCS, and then we're going to have some discussion of a 2016 initiative that came to my attention. I want to make sure everyone is aware of. It's 12:41 right now. Do we have any members of the public who are signed in to testify? No? Okay. Just want to keep an eye on that and make sure we allow time if necessary. Who's doing the presentation for DCS?
Aaron Atwell, CFO.
Oh, making a return appearance after several cameos at the last meeting. Thanks for being here today, Mr. Atwell.
Thanks, Chairman, Members Committee. As mentioned, I'm Aaron Atwell, CFO of Indiana DCS. So yeah, we're going to go through kind of the the rate setting process and highlights. And through this, we'll cover anywhere from kind of where we've been with the rate setting process to where we're at now. Highs, lows, kind of a few lawsuits, go through kind of how the rates are actually calculated. Provide some historical numbers from overall spend, overall kind of rates, utilization, and then go through kind of an example of how a rate is calculated and kind of really cover the entire process in general here. So Chairman, it's up to you. I mean, I'm happy to take questions throughout the presentation, save it for the end. There's a lot of information in here, so I will kind of defer to you.
Is this the presentation,
That is the presentation.
printouts? Okay.
Yep.
Why don't we try to let you get through your presentation, unless there's any confusion along the way, and obviously we can pause if there is, but let's save questions to the end and then we can have some discussion.
That makes sense. Okay, so process highlights. So we'll start off here. So from state fiscal year of 2012 to 2021, DCS has paid $2.4 billion to LCPAs and residential providers. And kind of on any given year, the average number of providers that we interact with.
Sorry, Mr. Atwell, your slide's not going to be up here. Okay. Okay. Do we have any extra copies of the packet?
We do have extra copies, correct?
Pardon? You have a
Yes, there
few? Okay. Mr. Young, can we make those available to folks in the room so others can follow along? And we can post this online later if it's not already posted, and make sure members of the public have access to it. Sorry for the interruption. I just wanted to make sure as many people had access to it as possible. Please proceed.
So kind of go back first. So from state fiscal year of 2012 to 2021, DCS has issued payments totaling $2.44 billion to LCPAs as well as residential providers. On average, we interact with between 75 and 80, providers annually. And so provider rates have actually increased an average of about 8% annually in kind of that same time frame. Our current rate setting process is data driven. It's thorough and it yields standardized results. So standardized results meaning that, current process is it's a formula, it's a calculation. You'll see later in the presentation that it's eligible cost divided by utilization generates a payment rate. So there's not really, any one person or any one process that is just arbitrary that kind of dictates or establishes rates for providers. Our model has been looked at by other states as best practice. So we demoed our model to states such as North Carolina, California, as well as Kansas, to kind of pick up on the different aspects as well as utilization, maybe cost reports, just really to get a better understanding of how we do our cost reports for residential providers. So I thought that was something that we should highlight. Indiana Administrative Code sets the processes and parameters and allows DCX flexibility to address provider concerns and input. One thing we did think that was great to highlight here is we're going through kind of an improvement opportunity right now to really understand and forecast, how we can incentivize outcomes. And so doing that without changing Indiana Administrative Code is something that we're in the process of doing right now. DCS is currently in the research phase. As the process is developed, DCS will be in constant, contact and communication and allow for provider input. So naturally, with any process, there's trial and error and kind of reform. So codifying changes, we just want to make sure that, we're not preventing measurable outcomes. So next slide kind of goes through the history of our rates. And before we kind of get into this, I want to highlight that you'll hear me probably talk about two different rates. You'll hear me talk about a payment rate as well as a 4E rate. So a payment rate is just the true payment that goes out to providers. So providers see for a bed utilization, and a 4E is a rate that is calculated internally currently with DCS that drives our federal reimbursement. So in kind of that payment rate, there's a standard maintenance payment as well as kind of a 4E administration portion. And on top of that, there's costs that DCS allows in that rate that go into providers. The 4E rate is not as generous, and that's more of your maintenance as well as your general 4E admin. And again, that drives our federal reimbursement. So prior to 2019, the rates were county administered. So counties would negotiate with providers at a county level basis. So if I was provider one and I was negotiating with county one, it could be one rate. And if I was still provider one negotiating with another county, it could be completely different rates. So there's really no set standard process on how rates were developed prior to kind of centralization of the rate setting process. The creation of, let me go back here real quick. And at that same time, when those rates were being negotiated, DCS vendors and contractors were calculating the 4E rate as well. So providers would be negotiating with county offices, but then they'd also be submitting their cost reports to a third-party contract provider to then generate that 4E rate for which DCS then pulled federal funding down. Creation of DCS in 2005 led to the centralization of rates. That kind of happened around the 2009 timeframe. So when I say centralization, it's still kind of a negotiated process similar to what we were doing in counties, but more centralized in 2009. I believe around the 2011, 2012 timeframe, in response, I think some budgetary measures, there's a reduction of rates kind of across the board, I believe around 15% for those county administrator, county negotiated rates. That I believe kind of led into the initial lawsuit filed by IARCA in response to those reductions across the board. There were a couple of things that came out of that settlement, but ultimately kind of establishment of some type of rate setting process was one of the key kind of turnarounds from that lawsuit. Also in 2012, we unbundled the rate. So to kind of explain it simplistically is that we We had expenses that were Medicaid eligible that DCS was paying for. We unbundled that rate and kind of sent those expenses over to Medicaid for Medicaid qualifying kids. So no longer DCS expense for kids in our care, but then transfer kind of over to Medicaid to have Medicaid OMPP as the payee. So a lot of things were happening around 2012. Rate process being set. The rates were being unbundled for Medicaid payment. 2012, 2013 timeframe, there was a system error that led to improper allocation of administrative rates. So that kind of reopened the IARCA lawsuit, I believe, around 2012 for 2013 rates. And again, that was an allocation issue on the administrative side. So all in all, real quick recap, rates prior to 2019 were negotiated on county level. Process continues to get better. 2012, as a result of a settlement, we start to define the rate setting process that we currently have today. Again, this just goes in a little bit more detail of the two kind of lawsuit settlements. The first settlement, again, was related to the percentage reduction across the board to the negotiated rates. So what came out of that was a payment rate that was the greater of a 5% negotiated rate reduction or the Title IV claimable rate. Also, what came out of that settlement, again, was the establishment of the rate rule. So basically saying that we need some sort of standardized process to determine rates. Second settlement, 2013, again, that was related to administrative allocation system error. There was a $5 million pool of funding that was to be used at the discretion of IARCA. The order in which that $5 million was used in was for to kind of establish child placing administrative cost limit to raise that, as well as fringe benefit and payroll tax cost limit as well. So that $5 pool was kind of spread out amongst those two really cost limits there. We'll get into cost limits here in a second as well. And kind of the final thing that came out of that second summit was ongoing face-to-face meetings just for provider DCS interaction and communication on the rate setting process. So Indiana Administrative Code governs kind of our rate setting process. So 465 IAC 2-16 through 2-18 governs the rate setting process for our residential treatment providers, our child placing agencies, as well as our department managed foster homes. Next couple slides, we'll talk about how our rates are actually calculated, what goes into them, what's allowed, what's not allowed, and kind of some enhancements that we provide to get the rate more up to speed or current time. Again, as I mentioned a little bit earlier, our eligible cost divided by utilization equal our payment rate. So you'll see that's eligible cost, not all cost, because there are some disallowances that I'll get in here in a second. And our rate year rates are based upon at most a 2-year gap between cost in those rates. So current our process right now, we're going through the process of setting calendar year 22 rates. Those are based on cost incurred in 2020. And at most, we say at most, because at most those rates date back to January 1 of 2020, but at the earliest, they're a year old dating to kind of December 31st of 2020. So we can't use 20 or 21 as we're obviously it's November right now, so we just can't use kind of a real-time number. So the most recent data that we would have for a full year of cost is 2020. So again, we factored those. Those are the cost reports that are submitted to my team then to determine rates. There are some rate disallowances that go into to kind of manage the rates and just overall rate setting process. So there's salary cost limits. That is one of the disallowances, and these go order as it applies to kind of the report. So the salary cost limit is based on the Child Welfare League of America study. So it goes by, I believe, gross revenue of the facility or the program that we are reviewing in the cost reporting process. And really what that does is set salary limits of what you can pay the employees, as well as any administrative staff that are within the provider in the program that's being submitted. There's a fringe benefit cost limit. So that's based upon self-reported data. Again, it's one of those to keep in line with kind of where everybody's going. So if you have a fringe benefit cost that is kind of above the standard average, we go out a couple of standard deviations. A part of that cost becomes disallowed. There's a staffing ratio and caseload ratio cost limit. So if your staffing ratios or caseload ratios don't align with the set licensing standards, there's some costs there that could be ultimately be disallowed. There's occupancy cost limit disallowances. So if your occupancy falls below with kind of the standard average, that factors into your eligible costs as well with some disallowances there. And then finally, there's an administrative cost limit. So again, the amount of self-reported data related to your administrative function goes into kind of what your eligible costs are. And if you're over kind of a certain threshold there, based upon all of the reports that are submitted, there could be some disallowances associated with the administrative cost limit. So that just covers our disallowances at kind of a very high level. And if there's specific questions about certain processes or how this is calculated versus that, we can definitely get into that here towards the end. Now, we've highlighted the rate disallowances, but one thing we do recognize and we do highlight is our rate enhancements. So we apply a cost of living adjustment to those cost reports. So we do recognize that for calendar year 2022 rates, that's based upon cost incurred in 2020. So part of our cost of living adjustment, it's a 2-year cost of living adjustment. So we apply cost of living adjustment to get that first year rates up and the second year rates up based upon the CPI as well as the employment cost index, which I think I mentioned last meeting as well. So we do kind of a 2-year bump up to get those rates to real time. Next, there's a stabilization factor that we'll get into here a little bit more, but that ultimately just mitigates rate reductions in lists. So if you're a provider who has received a pretty substantial rate reduction, whether it be based upon cost or utilization, we factor those. We try to mitigate that rate reduction through the stabilization factor. We talked about the 2-year cost of living adjustment. But another thing that we do is we understand that prospectively there may be inflation, there may be other costs that providers haven't seen in their 2020 cost reports for this calendar year. But we apply a 3rd-year COLA too. So we applied the 2-year COLAs for the prior 2 years, and then prospectively we apply a 3rd-year COLA as well. So really, the COLA is implemented 3 different times throughout this process. And last, we provide a profit margin, and that's applied to non-tax entities that I think everybody is well aware of. And again, just to highlight that COLA is based upon a combo of the CPI as well as the employment cost index. So results out of rate enhancements. So for 2-year COLA, to highlight, that is a made provision in Indiana Administrative Code. It's something that we have done throughout kind of life of the cost reporting process. On average, it's been about 4.04% increase to kind of the cost report since 2012. One thing to really highlight is this is added to the entire cost and rate, and it's not applied just to variable cost that would fluctuate with, say, inflation or CPI. It's added to both variable as well as fixed rates. So it's applied to all costs, not just a certain portion of the cost. Stabilization factor, didn't go back on that, not required by Indiana Administrative Code, but it provides important flexibility to assist providers when cost reports produce lower than expected rates. And it's really to help mitigate a rate reduction for providers. That 3rd-year rate adjustment for the COLA, again, not required by Indiana Administrative Code, but it's average of 2.2%, so same as the COLA, and that's been applied I think across the board since 2012 as well. And that goes above and beyond the 2-year COLA to cover additional operating expenses. And then the profit margin is highlighted in Indiana Administrative Code and is required to provide a reasonable profit margin to non-tax exempt entities. Kind of segueing into the next slide here. Wanted to highlight quickly the differences between for-profit and not-for-profit agencies and kind of how they impact DCS internally. It's close. Approximately 80% of our residential service providers are nonprofit. The other 20% remain are for-profit entities. Nonprofit entities receive benefits, including sales tax exemption, income tax exemption, and fundraising from tax deductible donations. For-profit agencies do not receive kind of the same tax and fundraising benefits. So to create parity, when the rule was established, for-profit agencies receive a yearly profit margin in the rates per Indiana Administrative Code. I mentioned a little bit earlier about kind of we would run through an example of kind of the rate setting process and the timing. So rates are due by the end of March. So agency submits cost report to DCS based upon 2020 costs. Cost reports are submitted through an online portal, I believe through iRate. The tool is about 13 pages long. The tool actually provides a real-time estimate rate to the provider at the time of the submission on what that potential rate could be. DCS calculates the rate. Again, rate is the allowable cost divided by utilization. We then apply rate enhancements, a 2-year COLA, a 3rd-year COLA, and if applicable, rate stabilization, as well as a profit margin. So November of 2021, we distribute rate letters for establishing rates for the next calendar year. Agencies have 30 days to request a review of their current rates. The next slide kind of goes through a table of just different timing and framing of when either a public hearing occurs, desk audits occur, as well as kind of highlights that there's ongoing processes of administration review as well as appeal and hearings. So you go through, you establish your rates, you send it out. Providers have 30 days to respond if they want their rate review. So Indiana Administrative Code provides for 1, a review, and 2, for an appeal of provider rates if that review doesn't reach a favorable opinion. Reviews, so these are cost adjustments that are submitted for review consideration. The committee reviews those requests and makes decisions based upon the provider submitted information. So since 2015, we averaged about 50 reports a year to be reviewed. Out of that, 57% have been approved and 43% have been denied. So that next kind of process, if you're part of the review that does get denied, you move over to an appeal. An appeal is administered by an ALJ, administrative law judge. And data kind of since that same time, for instance, 2015, on average, we've appealed about, or we see about 10 appeals that have been reported. Out of that, less than 1% have been approved, 20% have been settled, 30% have been denied, and 50% have been withdrawn throughout the appeals. A lot of the most recent kind of numbers of the review and appeal is a little bit less percentage than kind of what I reported, but that makes sense as providers have gained a great understanding of kind of the cost reporting and rate setting process. So I just think fewer rate reviews have led to kind of an improved and increased rates. So next couple of slides, we'll go through a couple of different areas. We'll go through the rates that have been established since 2012. We'll go through utilization as well as just general cost experience of DCS. So you can kind of see here that for private secure as well as child caring institutions, I mean, across the board, we've gone from anywhere from $277 per day per diem up to $478 for private secures, $187 up to $445 a day for child caring institutions, as well as group homes. I mean, they're at $149.95 per day up to $411.20 based upon kind of first glance at 2022 rates. And same kind of child placement agencies sees a similar trend going from $32 a day up to about $58.67 a day per child. And again, we only pay on the bed fill day. Next slide goes through our placement utilization. I think a lot of things that we talk about is really trying to make an impact on that residential number. So you'll see that in every category and every area, our utilization numbers have decreased since I think our highest time frame in 2017. So I wanted to just kind of show, we trying our best to get those kids out of residential in a proper setting. Slide 15 covers just by state fiscal year, DCF's experience in spend for the same type of providers, so LCPAs and residential spend. So going from $175.4 million in 2012 to a high point of $312.9 million of established and kind of experienced spend in 2020. Does dip back down to $283.23 million in 2021. So just wanted to kind of show the trend along with rates as along with utilization of DCS experience since 2012. So the rates for child care institutions have nearly doubled since 2012. The driver of lower spend being in 2021 is due to utilization. Slide 16 highlights kind of our future state. So where do we want to go? What are we currently doing right now to take a look at, any process improvements that may have. So we're continuously researching alternative rate setting process and methodology, whether it's looking at utility companies or any other child welfare, methodologies that are out there, really trying to focus on understanding a little bit better how utilization impacts the rate, trying to understand, is there a better way for us to adjust to more real time? Going to collaborate with providers to review current process and identify strengths as well as improvement opportunities. And as mentioned a little bit earlier, develop a process that factors outcomes into the rate without amending the rate rule prior to that statutory rule readoption timeline. It's kind of last slide. So just wanted to highlight our takeaways. The current rate rule and rate setting process functions well. It's adjusted to meet current costs through 2-year COLAs as well as a 3rd-year COLA and a stabilization rate. The rule gives flexibility that is needed by both DCS and providers to adjust when needed. I believe the process is transparent. Agencies know that costs and utilization will determine rates, as mentioned a little bit earlier. And rates will not decrease throughout the calendar year. So the rate which you receive is the rate that you're going to get all throughout the calendar year. Provider rates have increased an average of 8% annually from 2012 to 2021. DCS has paid more than $2.44 billion to LCPAs and residential providers in kind of that same time frame. So Chairman, that was fast. I know a lot of information, but covered pretty much where we've been from the rate rule process all the way to the end.
No, thank you, Mr. Atwell. That was a great presentation. And that gives us lots of time for the next piece and to talk about this piece with questions. So anybody have questions or comments? I have a number of things I wrote down. Mr. McCrindle.
Hi, Sean McCrindle from Basher. Just a couple of questions on the staffing ratio and caseload ratio cost limits. I know one of the things that's been working really well is DCS has been working with providers to try to create service standards for certain arenas. And the service standards seem to at times conflict with the caps related to staffing ratios, caseloads. Is there a way of overcoming that or working through that?
Yeah, definitely. I mean, I think we can work with our team on the service standard. I mean, just making sure that we're all in alignment on service standards as well as our costs. Absolutely. I definitely think there's a way that we can overcome it. I would need to understand a little bit more on the service standard piece, but definitely I think there's something like a middle ground for sure.
Okay, thank you. Also on the occupancy cost limits, we just heard last time, a lot of facilities are far below their normal occupancy just because of staffing issues. And so likelihood of in 2 years hitting some real occupancy limit issues could be there. Is that something that would be handled in a review process or more across the board, do you think?
Yeah, I think there's 2 measures. I mean, definitely for provider specific, on the review process, we know occupancy is going to be a major driver of that. That is something that we can review in the process. And I think in general, just looking at the occupancy cost limit overall and whether that, it's at appropriate levels, I think is definitely something we can take a look at.
That's all I have. Thank you.
Other questions? Let's go to page 3. Your last bullet says without changing the administrative code. Talk about that. Why not change the administrative code?
I think in order to incentivize outcomes, I honestly don't think the administrative code needs to be opened up or touched. I think there's a process that we can do maybe on top of the rate setting process. And again, I think we're in the beginning stages, but I think if you keep the rate setting process the way it is, but then, do on something on top of that incentivizes outcomes, is definitely kind of where my head was going with that and just talking. I mean, again, like I said, we're in the very beginning stages of it, but it would be on top of the rate setting process, not a component of it.
I was going to come back to this in a minute, but I'll go ahead. You said you're in the very beginning stages of it. It's my understanding that DCS has already engaged a consultant, right?
Yeah, we're already working on getting the research from other states and how other states do outcomes-based incentives as well for residential and licensing child placement agencies.
So what I was hoping you'd get into talking about the process you envision. What is the plan? Specifically, I'd be interested to know who is the consultant and what's the timeline and the plan for engaging stakeholders here in Indiana?
So I would say the plan is, so that we're going to revisit in January. We'll use a similar plan as we did with our family preservation services, where we submit an RFI to get information from providers. That's working with IDOA in that process. It works really well. It worked really well for that process. We don't see why it would work any differently for other processes. It's a fair way of getting feedback, and it gives them time to provide a thoughtful response so that we have the information necessary. I don't have timeline information for you.
So is the goal to restructure the rate setting process prior to the 2023 budget session, or
Not
can
the
you speak
rate
to
setting
that?
process, but being able to build in outcomes.
Okay.
And is there any way that we could build in incentives to outcomes? Right now, there is nothing that looks at what are the outcomes for the children that are in the facilities. And so determining what those outcomes are, working with the providers on what do those look like? How can they be measured? And that's pretty much it.
Who is the consultant?
CASO,
I'm sorry,
ACASO,
Acaso?
Yep.
How do you spell
with
that?
IDOA, IKASO.
IKASO. You say with IDOA?
Yep.
But they're not part of IDOA. They're a third party, right?
Correct. But we
Okay.
work with IDOA and their
Gotcha.
processes and their rules.
Okay. Thank you. Mr. Atwell, I want to come back to slides. Let's see. 7, 8, and 9. I guess 7 and 9 to start with. So I'm still struggling with this for-profit versus nonprofit. So the profit margin is allowed for in code,
The profit margin is required in code, correct?
right?
Yep.
Or required.
Yep.
Yeah, in code. Yep. So slide 9 makes this distinction though between nonprofits and for-profits, and I want to be fair about it because it outlines the supposed benefits that nonprofits have, but it doesn't speak to any of the benefits that for-profits have. So can you talk about that and talk about what some of those benefits may be?
So I mean, when talking nonprofits versus for-profit, obviously, yeah, we highlighted the nonprofits. I mean, the for-profits, I'm just trying to think of exactly, there's fundraising ability that they have. I mean, similar to nonprofits, I mean, they can all fundraise, but you know, to the exact benefits that a for-profit has over a nonprofit, I'm not exactly sure in terms of a tax implication or anything like that.
Well, I think tax implication is part of it,
Okay.
because it seems to me, and I'm not a tax expert, but for-profits enjoy certain benefits that, I mean, we can agree that there are certain things that nonprofits can do, such as fundraising, that for-profits can't do. Now, fundraising ability, I'd be interested to hear from some of the nonprofits, because what you term ability, you know, I think some of them may view as necessity, obligation, even burden sometimes, because obviously it takes resources to do that fundraising. But we can agree certainly that nonprofits have that ability or have that that mechanism available. But with for-profits, they can deduct business expenses, for example, including employee health insurance and other benefits and such. So I'm uncomfortable with this. It seems like a lopsided distinction between for-profits and nonprofits. I think, you know, each has advantages. And on slide 9 here, it seems like you're highlighting advantages that nonprofits have without acknowledging that for-profits also have certain advantages. And I would just draw your attention to that and challenge you to consider that. When I was looking at slide 7, and it talked about at the bottom of the slide, profit margin applied to non-tax exempt entities. I was just thinking, in the same way that we have for-profit and non-profit child service providers, it seems like we have that in lots of other areas too. And I think it might be useful to think about other places where we encounter these differences and look at how entities are treated or not treated differently. It may be a poor comparison, but I think of utilities, for example. I mean, you have investor-owned utilities, you have municipal utilities, you have co-op utilities. So, each in that case meets a community need, and each has advantages and disadvantages. So I don't know. I'm uncomfortable with the assumption being that nonprofits have the upper hand. So would you like to comment on that anymore? Or?
No, I mean, yeah, we're highlighting, excuse me. So it's just a discussion of the operating margin on the nonprofits. And, I think when just looking at the rates, they're pretty level across the board. So no.
Yeah.
Well,
Director
and just
Stigdon.
let me add, looking back in history as to why that decision was made, we're trying to figure out why that decision was made to put one in administrative code and one other. It's not a competition. It's just a matter of looking at why the decision was made and trying to understand why that decision was made.
Right.
And trying to make sure that you guys understand why that decision was made.
Which is good. I don't want to get stuck on what may be I was going to say artificial distinction. It's a real distinction, but what may not be an important distinction. And again, if the focus is going to be moving to looking at outcomes and such, then I think that it probably makes the distinction even less relevant. We want everybody to be able to provide services and get to desirable outcomes. Jump over, please, to slide 8. I was going to ask, you said in your third bullet point, Mr. Atwell, not required by the administrative code on the third year COLA. So should it be?
Required? No, I mean, it's something that we're doing currently.
Pardon?
The third year COLA has been in place. I mean, it's something that we're doing currently and it's part of our process.
Yeah.
Yep.
But should it be an administrative code?
I don't know. I mean, when looking at all these COLAs, they're all May provisions. And so I'm not exactly sure whether, it should be in code or not.
Okay. Jump over to slide 10, please. The first bullet, you said the tool is approximately 13 pages long.
Yeah.
I'm not quite sure how to interpret that. Is 13 pages good or bad?
I think it all depends on.
It seems bad to me.
How efficient you are.
It just is.
Yeah.
Yeah.
Like I said, I think we're just trying to identify the process and not trying to make a statement what, good or
Right.
bad. We're just trying to let everybody know, hey, here's the process. Here's how it works. You got to complete a 13-page. I mean, there's a lot of information that goes into it. So I just wanted to highlight that process.
Yeah.
Good or bad, I honestly not.
I mean, I think it relates to what I've heard from a lot of providers, and that is just the cumbersome nature of the rate setting process.
Okay. Yeah, that's fair.
Pardon?
I think that's fair.
On the next bullet on that same slide, DCS calculates rate. Rate equals allowable cost divided by utilization, and then parenthetically number of children served. So you're not just looking at number of children served, you're looking at complexity and level of care and things like that, right?
So in terms of just the allowable cost, so when cost reports are submitted, they're based upon the different types of programs. So whether it's private, secure, whether it's kind of the child caring institution, all that's taken into consideration when the reports are submitted.
Okay. Slide 12, and if anybody else has any questions, feel free to jump in. I don't mean to dominate the discussion, but I'm just going through notes that I made during Mr. Atwell's presentation. Slide 12, 50% are withdrawn on the appeals. Why do you think such a high percentage, half of the appeals are withdrawn?
I'm gonna defer to my deputy CFO on that one, Todd Fondre, because I don't have experience. I've only been through one kind of on the back end of a rate setting process, but I will, Todd, if you got additional comments, or I can get you that information a little bit later.
Todd Fondre, Deputy CFO, DCS. To answer the question regarding the 50% withdrawal, I don't know why per se. Each provider has their own reason for withdrawing their appeals once it gets to that stage in the process. Some providers, just from experience, will state that they don't want to go through the appeal. They just wanted to have the pre-settlement hearing prior to the appeal. So they'll go through that process to see if there's any positive outcome from that process. And if there isn't, they'll just go through and withdraw the appeal.
What's typical of the settlement process with the 20% that are settled? What does that typically look like?
As far as the monetary value or as far as the process just itself?
Both. I mean, how long does it take and where do you usually land, closer to one side or the other? Or is it typically, average the two and agree to be in the middle, or what's typical?
It's hard to really provide a typical answer to that because each provider is different. I can say for the process itself that if a situation arises that was not uncovered during the desk audit process or anything that the rate setting team would know in advance, that those adjustments will be made in hopes to not have to go through the appeal process. So it's not saying that, XYZ is covered, XYZ is taken into consideration when a provider submits that to us. We take into consideration anything that may be new that didn't go through the administrative review process nor the desk review process.
And I assume the less than 1% approved is because the ALJ process by its nature is looking at process rather than merit, right?
I would say that's accurate, yes.
Okay. Thank you. I think that was all the questions I had. Anybody else? Mr. McCrindle?
Yes, Sean McCrindle, Basher again. One, I would say yes, the 13-page paper never makes it to the fun side of your list, but it does give a pretty good understanding for providers of probably where you're going to fall or within a range for your rates, which is good for our budgeting process.
Sure.
So while I don't think anybody's going to say, yeah, let's do more pages, it does give us kind of an understanding. And in some cases, well, usually it's more conservative than where you end up.
Exactly.
And other things like that. So the tool is useful that way. And I also think it's important to state from a provider's perspective, especially from our agency, your department has been very helpful in trying to figure out what things do fall within and outside of the costs that can be utilized and ways that we can try to find new ways of funding certain things or whatever. And so I really appreciate that. I know you guys have a lot of really tight structures you're in, but your guidance has been helpful in several situations to our agency and others.
Thank you. Goes to Todd and his team.
Other comments or questions for Mr. Atwell? Excuse me. All right, well, thank you. We may ask you to come back here in a few minutes. Oh, I'm sorry, Representative Jackson, did you have a question? Mr. Atwell?
Aaron.
I'm sorry. Yeah, I'm looking here, and one thing that sticks out in my mind is when we look over here on the page with the reviews and appeals, and you have here that pretty much 1% is approved. To me, that seems kind of a flag goes up. Could you kind of explain a case where an agency who files an appeal and they happen to get approved? Could you just give us a brief explanation, please?
Yeah, sure. I think to kind of speak to what the chairman's last question was, just the process in general. So when it goes through that review process, it gets denied, it kind of goes to that next step to the appeals process. And then the ALJ is looking at the process of that. So, I mean, just going through and seeing whether, we missed something, we should have taken something in consideration, et cetera. So again, it just looks at the specific process in place on the appeals process. And again, looked at it by ALJ.
Thank you.
Thank you. Okay, then we have a two-page summary here that is titled 2016 Indiana Child and Family Welfare Collaborative Rulemaking. And Mr. Daly, did you want to come up and talk about this? This came to my attention. I think one of the things we always have to be mindful of in state government is oftentimes things have already been initiated or have been considered previously, and we're not all subject matter experts in obviously all of the areas of state government, and it's impossible to keep up with everything that's happening in state government. So I was not familiar with this 2016 process that went on, so I wanted to at least bring it to the committee's attention today and make sure that the work that went on back then is incorporated into, or at least considered as we move forward. So, Mr. Daly, thank you for preparing this document. You want to go ahead and give us a little background?
Absolutely. Thank you, Chairman. Again, it's Chris Daly, the Executive Director of IARCA. I think what's incredibly helpful about Aaron's presentation, then followed by a review of what happened in 2016, was understanding that, and as Sean has already said, that there's a lot of good in our existing cost-based rate setting process. The challenge is in the actual implementation of the process. So what happened, Aaron's already kind of laid this out. IARCA had to sue to get the cost report process in place in the first place. A judge found that the reductions that DCS made across the board were unlawful, right? Had to come back in 2013 because, as Aaron said, because of a technical error. And so kind of leading up to that, there were a lot of discussions between the provider community and the state around what the cost report process should look like. And so that all culminated in 2016 with DCS pulling together about 25 folks from their staff and from child and family welfare agencies, specifically from residential and foster care agencies, because that's whose rates are set by the cost report process. And I think what's really important to understand is those folks sat down in a room, went through the rules, and kind of figured out where the way the rule had been implemented was creating some unintentional consequences in the rates that resulted, and tried to come up with some collaborative solutions to what that looked like. And I think it's also just important to understand that in that room, it was about half DCS and half child and family welfare agencies. It was the kind of public-private collaborative that we talk about all the time. And that's what we kind of see in this document. I think that it's helpful to just recognize that the recommendations that we're going to talk about were ones that were documented by DCS, right? DCS were the ones that kind of generated this document that you all have seen, this draft document. It was signed off by the general counsel at DCS, all with the goal of saying, we want to make sure that what we're spending, what rates we're giving you are covering the costs, right, that you incur in serving children. So with that as background, again, there's two different rules that I'll talk about today. This is Rule 16, which has to do with residential rates, and Rule 17 that has to do with the foster care rates. There were some additional recommendations to Rule 18 having to do with the DCS foster homes that we won't go into today just because of time purposes. So, and there's a lot of similarities, but not complete overlap between the recommendations that DCS put forward in 2016 and how to make sure the rate setting process covered costs. The first one, and again, this goes exactly to what Chairman Claire was saying, is that simplifying the cost, the way in which we kind of look at costs. There's a lot of definitional language in the admin code, and that what the folks at the table decided to do was look back at how did the feds define maintenance payment, or sorry, maintenance related costs and administrative related costs and unallowable costs. Those became kind of three core structures of understanding what costs should make up a cost report. And it did, the recommendations would do away with a lot of verbiage in the admin rule and would point back to some federal rules. Again, just a way to kind of simplify how the process would work. And then Aaron talked a little bit about enhancements. This recommendations for both residential and Rule 16 and for foster care and Rule 17 look specifically at the adjustments Aaron was just talking about. So in addition to the annual COLA that's already there, it recognized both an operating margin for nonprofit and a profit margin for for-profit. Again, this is a DCS recommendation recognizing that no business, doesn't matter what your business is, can operate on cost. We can't expect our system to work well if the businesses who work with our children and families are expected to operate on cost only. There's no room for innovation. There's no room for enhancement. There's no room to move forward personnel costs. I think the thing that may have great presentation from Aaron. I think what may have been missing is the complexity in our services 2012 versus now. It is almost night and day how much more complex our agencies are today than they were back in 2012. That is something we should be proud of in Indiana. A lot of the requirements that the federal government put in place as part of the Family First Prevention Services Act, sorry, a lot of terms out there, really had to do with things that Indiana had started doing in 2012. And every single one of those things costs money, right? So to imagine that our agencies could respond to new methods of treatment, to pressures around personnel, to aging facilities on a cost-only basis, this collaborative process recognized that makes no sense, right? That there has to be some kind of margin as part of the process. And then finally, in addition to those, there was a line that would have been added to the admin code and other reasonable adjustments based on data received individually by each agency. Annual comments and independent review. So again, I think that the collaborative process really sought to simplify things. Right now, there's both a written comment period and a hearing that happens as part of the administrative rule. This would have done away with the hearing. It would have made annual comments the way in which agencies provide input to Director Stigdon's earlier comment of just making sure that every agency has the opportunity to provide input. And there's, I don't actually think this is taking place. If it is, somebody needs to point me to it. There is in the rule a requirement that the agency every year have their rate setting method evaluated for residential by an independent agency. It would have done away with an independent entity. It would have done away with that requirement because again, I don't think it was happening in 2016. I don't think it's happening now. The idea would have been, let's just make sure that our admin rule is much more practical. Here's the piece that Sean was getting at earlier around staffing in residential agencies. It completely changes how we look at staffing, right? The changes that DCS envisioned were, you come and tell us what your staffing needs are. Present us a staffing plan. Tell us what it's based on. Is it based on your licensing requirements? Is it based on our service standards? Is it based on the acuity of your children? Sit down with us and talk to us about what your staffing needs to look like in the next year. We'll kind of go back and forth with you on that, right? We'll approve it. If you don't like what we approve, you can appeal it. But it's much more focused on what does this facility need in order to meet the needs of their children. And that's exactly what Sean was kind of pointing to earlier, that right now there's conflicting ways in which DCS licensing and DCS finance look at the licensing requirements. There's the service standards. All of our agencies, all of our residential agencies are now accredited. Those national accreditation requirements create different staffing requirements. The way that the collaborative process looked at is it folded all of that in. It charged the agency with saying, here's what our staffing is, here's how we can prove to you it's necessary. It then gave DCS the opportunity to engage with them. It would do away with a lot of the challenges that we've talked about as it applies to staffing that you all heard about a month ago. And then finally, as part of this, it would require a mid-year review of rates. Aaron testified to this as well, that once your rate is set in November, that's your rate till the end of December, right? So if there is a workforce crisis on, and you're having to raise your personnel cost by 18 to 20 to 40%, what you all heard a month ago, right? There's a mid-year review that takes that into account and responds in real time to those costs. It doesn't require you to wait 2 years to invest money that you're not getting as part of the rate. Because remember, if you're a nonprofit, the rate is zeroed out. And as Aaron testified, even for profits, the profit margin isn't based on actual money for innovation. It's based on covering taxes, right? So all of these agencies are operating kind of at an even base. So what this mid-year review would do was allow the agencies to come back to DCS and just kind of look at what are our actual costs, and do we need a boost in our rates to be able to make sure that we have the resources we need for families and children. So I think that, again, you'll see very similar things that happened in Rule 17. This again is the foster care. The one kind of tweaks that I'll just point out to you is there's not a requirement that the foster care rates be reviewed by an outside agency. That's something that's encouraged by the admin rule, but it's not required. That would have been stripped out regardless. And then around enhanced rates, there would be a way in which agencies could look at the children who are being served by the foster families that they provide services to, and make sure that the acuity of those children and the accompanying staffing needs and needs of the family who are providing care to those children are covered in the rates, right? And so again, there'd be an enhanced rates piece having to do with both the acuity of children, the travel that's required, right? There's all kinds of travel that's required for many of these children, making sure that if it's above the rate, above the standard measure of travel, that it can be incurred. So what we saw in this process, and again, back to Aaron's point, there was no move to throw out the cost report. No one is saying we should throw out the cost report mechanism, right? That there's a lot of good in it. It follows the federal law that the 4E statutory requirement that the rate covers the cost. What DCS had found leading up to this 2016 is the implementation of the admin code just wasn't working, right? That makes sense. It was developed in 2012 following a lawsuit. There was no kind of test run of it. It was implemented. This was a chance about 4 or 5 years later to perfect it. Now, to be really clear, this didn't move forward. It didn't happen. DCS wasn't able to achieve this. But I think when you all heard member agencies come and talk to you a month ago, how many of the issues did they raise that are embedded in these changes to the admin code, right? It's like everything that folks brought up is a part of the recommendations that DCS made in 2016 about how to update the admin code. No one is saying revising admin code in Indiana is easy, right? And largely, as I understand it, the timeline having to do with making those changes, the change in the governorship between the end of 2016 and early in 2017 as we had a new governor, all of that just kind of derailed this process. But again, to Chairman Clear's point, just because a decision was made in 2012, we shouldn't feel bound by it. One of the best things that Director Stigdon came in when she joined DCS was a fresh view of how we were doing things, right? And really looked top to bottom at how we can better serve families and children. And our system is better for it. And what this collaborative process allows us to do and the recommendations it made will allow us to apply that same sense of kind of critical review of how we're calculating rates and how we're making sure ultimately that children and families have what they need because the agencies that serve them are strong and are able to innovate.
Thank you. Questions, comments?
Do you know why? I was looking to see if it's something we've ever filed to amend the rule. Do you know what happened? I can't find it on the register.
There was never. So
okay.
as I understand it, and again, my understanding, I talked to my predecessor, Kathy Graham, who was in the position for 17 years and led this process, is that the change in leadership at the governor's office really just kind of put this on the back burner and it never got pulled off.
So nothing was ever filed, like a notice of rule change?
No.
Okay.
No.
Yeah, I think, my interest in bringing this to the committee's attention and to the public's attention is that it sounds to me as though there was a very lengthy and involved process that brought together a lot of stakeholders over a period of months, right?
it all culminated in a meeting in November, and I believe there was plenty of pre-talk prior to that.
Right, right. I just don't want us to lose that as we move forward. So there is a new sheriff in town. So Sheriff, do you have any
Hey.
comments?
And I have a badge. So some other things that were going on, which the legislature, I think, is very aware of. I don't know how many other people follow it, but at that time, DCS was hemorrhaging money, spending a lot of money, not just state dollars, but also overuse of federal funds. This plan would have cost, money, essentially. So that's just the basic part of it. But looking ahead, just, a lot has changed in 5 years, not just us and what's happened in the state, but federal law, state law requirements. We have new legislation at the federal level being introduced that changes how we do things. We just look forward to the new process that I talked about before and making sure that we continue to work with providers and how do we include outcomes and if there are things that we can look at in the rule that Aaron talked about earlier today, we look at that. So,
Don't you think there are pieces from the previous process, though, that we
I
can
haven't read through
draw
all of
from?
this. I just got it at the end of last week. I had a lot of things to do. So I haven't read through all of this, so I'll have to read through it before I can say anything about it.
Sure, but you're familiar with the previous process.
I was not, I mean,
Right,
I
you
got
weren't
here in
here.
2018.
Right.
So no, I have not talked in detail with anyone about this process.
Right, but you talked about how it would have cost money.
Yes.
Yeah.
Yeah.
Okay,
Yeah. I mean, look at the year. It was 2016. I know that.
Mhm. Sure.
I didn't have to know about this process to know that.
Yeah. Yeah, I just don't want us to lose the work that has been done previously. So other questions or comments?
Just in closing, I would say that the director is exactly right, right? It would cost money because we're underfunding the services that we're providing to children and families. Judge Kenworthy talked about that a month ago at our meeting and the consequences of doing that underfunding. But just, can we be clear? Because DCS isn't spending that money doesn't mean those costs aren't there. Sean's agency is absorbing that. Hundreds of agencies around the state are absorbing, those costs don't go away because the state isn't bearing that. They are now borne by not being able to offer raises in a timely way or having to offer less raises than a person deserves, not being able to do innovation, not being able to keep up facilities. Those costs continue to be borne day in and day out by agencies. And so I think that what this did is try to make sure that the state was paying its fair share of those costs.
I'm going to put you on the spot. IARCA has for-profit and nonprofit members.
Absolutely.
So will you go back and talk about the slide that listed the benefits for nonprofits and the comments I made about drawing distinctions between the two and how we're not talking about, I mean, it's fine to acknowledge that nonprofits have certain abilities that for-profits don't, but that's a two-way street, right? So talk about that.
Absolutely a two-way street. And listen, I totally respect what the director and Aaron were trying to do is kind of look back in the past and figure out why something was being set up the way it was. That's admirable. There's no sense from the record, again, we're on a whole different side. Like what we understood, there was no sense that the profit margin had to do with covering taxes, that the profit margin simply had to do with these are businesses and they need a profit margin. And so to Representative Clear's perspective, our nonprofit members are completely in support of our for-profit members having a profit margin. Our for-profit members are completely in support of our nonprofit members having an operating margin. Everyone is trying to make their bottom line work at the same time that they're trying to improve services for children and families. They can't do that without profit. And they can't do that when the money that they raise from the community when you're a nonprofit is covering the gap between what the rates pay and what it costs to provide services. Aaron's exactly right. As a state, we're investing a lot of money in these families and children. We should be, right? We should be as a state. You all know that. You know what these families are going through. You know what these children's futures look like if we don't invest that money. It costs a lot of money to do what we're doing, right? The idea that any of our businesses can succeed in the mission that we've set before them without a margin, it doesn't make a lot of sense to anyone who's doing this work. So I think that's why both margins are included in the collaborative rule. I think that's why we've come again and again. I think that's why Director Stigdon instituted the operating margin for nonprofit agencies in 2020. Everyone recognizes that these agencies have to be healthy. This is not a clash of philosophy, right? DCS is trying to work within its budget. We 100% get that. This is, we're partners in the work that we're doing, just like the for-profits and the nonprofits are partners in the work we're doing. And so that's where DCS just needs some help from you all, from the General Assembly, from your contacts with the executive branch to just say, of course, there needs to be an operating margin. We, as a state, we don't need to be making distinctions between how a corporation is set up. And if we do we really want to be under investing in our nonprofits who any margin they have is invested directly back into the children and families that we're serving? Is that really the side of that we want to be on? So I think that's, to that slide, Aaron's right. There are some advantages to being a nonprofit. There's a lot of deficits to being a nonprofit as well. So I think the fact is that the collaborative rule looked at this and came back and said, of course, everybody should have a margin. And that's where we'll get to, right? It's going to take us a while to get there. I know that the folks at DCS agree with us if we can find the money for it. So this really is about a partnership. It's not nonprofit versus for-profit. It's not DCS versus private sector. It's all, how do we do the best for families and children?
Well, and again, I'm concerned about holding up fundraising as some sort of a benefit because fundraising takes work. And I've been involved in countless nonprofit fundraisers over the years, and they can, they often are great community activities and a lot of fun. But for the folks who are doing the hard work of making it happen, they're not necessarily fun. So I struggle with that a little bit because it seems like it's sort of analogous to an individual who decides to take on some sort of a side hustle to earn extra money. I mean, it's great that they have that opportunity, but it takes work, right? If I'm going to go out and DoorDash or drive an Uber or something, then yes, I have an opportunity to earn more money, but it's going to take time and effort to do that. And I think you've talked before at our last meeting, I think this came up about how the personnel costs, the staffing costs for fundraising is excluded from the cost reports.
And the hard cost to put on an event, all of those, none of those costs actually make it into the rate that's then offered to cover the cost. So again, it's understandable that we're looking to the past to try to figure out why this dichotomy was put there. It all falls apart though, as Representative Clear just said.
Well, I want us to look forward. So figure out what we need to be doing going forward. So I appreciate all the insight and thank you for reminding us about this 2016 undertaking, and hopefully it will be considered as we move forward. Any other comments or questions for Mr. Daly?
Thanks so much, everybody.
I hope the folks online are hearing okay and able to weigh in. If I think we have Senator Mervan and Ray Feller out there, so we'll move to, let's see, number 7 on the agenda, public comment. I think we don't have anybody signed in for public comment. Is that correct? Speak now. Okay. Always want to have the opportunity for public comment. And as I've said before, this is not a forum for addressing individual cases or offices or case workers or anything like that. If there are those types of issues, you're welcome to contact my legislative assistant, Mr. LaPrette, and I will deal with that as appropriate and bring in other legislators or DCS or whoever needs to be involved in those discussions. But we're always happy to take general public comment at these meetings. Committee discussion. including our two folks who are online or who are virtual, I should say. Is there anything the committee wishes to discuss?
I was going to point out, I know in the administrative code, I found a couple of citations to an old circular or fiscal circular. And I think that doesn't, isn't still doesn't control DCS. I think there's a new fiscal circular, so that would be another reason to modify the administrative code is to update the references to the federal fiscal documents.
So you're saying there's some outdated references,
I think so, yeah.
federal references in the administrative code.
Yeah, I've done a deep dive. I think they're, like, you know, for some of the rates, I think it's a 2-year look back, that points to a fiscal circular. I think that was overwritten when the big super circular was adopted by the feds. I think, I'm not sure, but I'm going to guess some of these are outdated. Sites.
Other discussion? Anybody? Ms. Smith, you've been quiet today. All right. Well, there's been a lot to take in. I appreciate all of the information. I hope it's been useful to the committee members. I think we have a lot to think about and some things to work on. I'm very interested in what Mr. Moore presented on alternative permanency options. And again, I would hope that we could at least have a discussion about some incremental steps if there are opportunities to break this down into bite-sized pieces. And certainly would defer to others who have been working on this and the other groups and such, but I appreciate the information and the ideas that were presented today. And then clearly with regard to the workforce discussion follow-up from the last meeting, we have a lot of opportunities there, both with DCS and with the legislature. So look forward to continuing those conversations. And the urgent matter is anything having to do with the legislation that we will be considering next Monday to make sure we don't miss an opportunity to do something in that legislation if need be. And then again, I appreciate the presentations on rate setting, and that's going to be an ongoing conversation. So Director Stigdon, did you have anything else?
I do not.
Anybody else? All right. Well, we're actually going to end a few minutes early, and I appreciate everyone's time and wish everyone a happy Thanksgiving, and we will adjourn the meeting at 1:51. Oh, that's adorable.
Yeah, she was.
How old is she? Granddaughter. Wow. Well, that was a lot of great information. Thank you.
I hope it's helpful.
Oh, that was very helpful.
Like I said, it's not a competition or anything. It's just based on the information.
No, it's very helpful. I am very concerned about this legislation that we said we were going to entertain on Monday.
For the end of the public emergency, you mean?
Oh, you just.
So some of our information. Yeah. We're waiting to hear the final result.
Yeah, I did. Yeah.
The impacts on our kids that get fully funding. That is not.
Yeah.
So we're trying to figure out.
Oh, wow. Yeah. Yeah. You want to get going, I'm sure.
So for background check, all the way back to.
Yeah. Yeah, I've got something.
Are deemed will be eligible.
Okay.
So that do not have anything in there that says we can decide to do it as a state, but then we leave out funding. Yes. Yes. So that's the federal implication. So what is the federal? We don't know. So that's what we're trying to look at. And we're trying to make sure that we understand it. We're going through our research.
But we avoid that right now by being in a state of emergency, right?
Well, that's what we're trying to find out. Are we really avoiding it because we're outside of the federal emergency? So remember, the federal emergency ended on September 3rd. And we haven't been asked for any waivers since then. So there hasn't been a need to look into it, right? So whether or not these, what I'm trying to say is the state extension didn't have anything to do with that. It was the fact that we were under the federal emergency. We didn't have to change anything in the state, in the executive orders. If you know, we didn't have to put anything in there because it wasn't impacted by the state. Because we were covered. Right. Does that make sense? So there was nothing in the state that told us to do that. So the question is, if we did extend it or ask for an extension, because I know you guys are looking at Medicaid, SNAP, and what is it, Department of Health Authority,
Oh, yeah.
or Dr. Box.
Yeah, the standing.
Yeah.
Yeah, I left that out.
With
but yes.
that,